So, good afternoon, women. It's been an absolute pleasure to connect in person with so many of you from the movement today. And thank you to Anna for organising and inviting me to speak. So, I'm presenting in my capacity as a women's rights advocate. I'm a law graduate and have recently been accepted for admission as a solicitor. So I just need to clarify that what I'm saying is for general interest and not actual legal advice. But if you have any questions, please feel free to contact me and I'll do what I can to point you in the right direction. So I'm going to be talking about Australian laws and gender identity and how that affects us as women. And when I say women, I mean females, adult human females. We are not a collection of disembodied parts. We should not be recognised by our bodily functions, which is exemplified by the demeaning words currently being used, such as pregnant people, uterus havers, breeders, chest feeders, and so on. We are not women because we perform regressive, restrictive, feminine stereotypes. We are women because we exist in a female-sexed body. And throughout written history, back to when patriarchy first arrived in about 3100 BC, women have been exploited and oppressed for the reproductive capabilities of the sex class to which they belong. So I acknowledge that I am probably one of the most freeborn women since the dawn of patriarchy those millennia ago. Nonetheless, like most of us I suspect, in the course of my life I personally have experienced male violence, male control and discrimination on the basis of my sex. Yet I am able to stand here today to talk freely, and I've been granted the opportunity of a platform, and for that reason I feel it is my obligation to speak up for women and girls who cannot speak for themselves. So, to the impact of gender identity ideology on our federal Australian laws. Our federal parliament is empowered to make law under the Australian Constitution, which grants the legislature 39 different heads of power to make laws with respect to matters as diverse as marriage, corporations, taxation and military defence. For our purposes today, it is the head of power known as the External Affairs Power that primarily enabled the enactment of the Commonwealth Sex Discrimination Act in 1984. This power constitutionally enables the government to have relations with other nations and to give effect to our obligations under international treaties and conventions, amongst other things. So this brings us to Cedaw, the UN Convention on the Elimination of All Forms of Discrimination Against Women. Adopted by the United Nations in 1979, ratified by Australia in 1983, it has now been ratified by over 189 states. So to give effect to the convention, we enacted the SDA. In fact, we were so serious about it that it was incorporated into the SDA in its entirety, giving it the same legal force as any other federal law. Its main purpose was to make discrimination against women in the public sphere unlawful in employment, education, provision of goods and services, and the prohibition of sexual harassment in employment. This was to enable us to compete for jobs and social goods on an equal basis with men. But a couple of points. The legislation is silent on matters of the private sphere, and it is sex neutral. So despite the original purpose being for protection of women, over the decades we have begun to see males begin to claim discrimination on the basis of sex. So the public and parliamentary debates that happened at the time were ferocious and protracted. Fears at the time were that the bill would give rise to a totalitarian regime, a blow to democracy, the creation of a unisex society, and the demise of the nuclear family. Thornton and Luca wrote a fascinating paper on those debates, and they unearthed such nuggets as Senator Pat Giles pointing out that it was beyond the government's power to legislate to eradicate the differences between the genders. It's interesting to consider those fears in light of the political climate in which we currently find ourselves. In any case, fast forward to 2011 and the federal government attempts to push through an omnibus bill called the Human Rights and Anti-Discrimination Bill, which incorporated protections for gender identity. Ultimately, the bill failed. So in the dying days of the Gillard government, the Sex Discrimination Amendment, Sexual Orientation, Gender Identity and Intersex Status Bill was introduced to make amends to the STA to give effect to these 3 new grounds for discrimination. The Senate and House inquiries for this bill essentially relied on submissions made for the failed Omnibus Bill, so it was passed almost unnoticed. Looking into the parliamentary papers and debate at the time, there was not a single instance of acknowledgement as to the impact that this might have on women. There was no discussion as to any conflict that might arise between the characteristics of sex and gender identity. There was one small exception with Section 42 in relation to sport, where the Attorney General specifically said that this provision was for the purpose of acknowledging the biological differences between men and women. So there is a constitutional argument that could be made that no head of power exists for biological men to claim protection under gender identity provisions. The Cedaw Committee put forward updates from time to time, and these are known as general recommendations. In 2011, mention was made of gender identity. However, it is explicit in that it only covers females and their gender identity. It offers protection from discrimination to biological females as distinct from biological males. Therefore, it could be argued that the gender identity provisions in the SDA cannot be relied on by biological males. So the arrogance and foresight of trans activists is apparent in a brilliant sleight of hand where the amendment bill made changes to 2 critical definitions. Firstly, the existing legal definitions of woman and man were removed, a woman being a female irrespective of her age, and same for men, on the understanding that the words would now adopt their ordinary meaning. The purpose of this was to redefine the category of woman to include men who identify as women and make sure that trans women were not excluded. No discussion whatsoever about the impact of men being able to self-identify as women. No mention of what women might think having to share spaces with male bodies. Clearly, it was in the confident expectation that these postmodernist inclusive definitions would be accepted as the norm. And as we can see with the benefit of hindsight, they were pretty justified in their confidence about their plan to re-engineer our language by fiat. Secondly, the definition of sex discrimination was amended from opposite sex to different sex to reflect the understanding that people may not identify as either male or female, despite the existence of a third sex or being able to change your sex being completely impossible. The concept of sex in our federal legislation was thus successfully re-engineered to accommodate subjective feelings and self-declared identity. It's clear that the plan to entrench the ideology into our legislation, the obfuscation of ordinary language, the intention of erasing the category of women and of sex has been in play for well over a decade. So let's look at these protected attributes. So intersex status is defined as the status of having physical, hormonal or genetic features that are neither wholly male nor female, a combination of the two, or neither. This ideological nonsense, considering that intersex conditions are a disorder or variation of the sex development of either of the two sexes, that it is referred to as a status instead of acknowledging it as a congenital medical condition that can be complex at best, cause heartbreaking infertility, or be life-threatening at worst, is an affront to those who have these conditions. Its weaponisation in these debates is resisted by those who suffer from these conditions. Secondly, sexual orientation. A person's orientation towards persons of the same sex, a different sex, or persons of the same sex and persons of a different sex. When most people think of sexual orientation in a discrimination context, they would think this pertains to people with the same-sex orientation, the LGBT community. And based on the history of discrimination towards gay and lesbian people that continues in many parts of the world, these are justifiable and welcomed protections. But instead we find a limitless definition that captures anyone and everyone, regardless of sex or gender identity. And then finally, Gender identity is defined as the gender-related identity, appearance or mannerisms or other gender-related characteristics of a person, whether by way of medical intervention or not, with or without regard to the person's designated sex at birth. The definition is circular as it relies on itself to define itself, and sex and gender are no longer defined in the Act or in Cedaw. Again, more newspeak. No one is designated a sex. It is determined at fertilisation, observed at birth and immutable. Designation implies it is arbitrary and can be changed. The explanatory memorandum stated that gender identity pertains to a person's identity, how they present and are recognised, based on name, outward appearance, mannerisms and dress. So a person could claim discrimination on this basis: their name, how they choose to dress, or how they speak and behave. So this section introduces a subjective category of self-declared personal identity as a protected attribute that relies on stereotypes. And it should be noted that Cedaw specifically states women should not be discriminated against on the basis of stereotypes. These absurd and incoherent definitions come from a document known as Yogyakarta Principles. This was drafted by a group of private individuals who have spent considerable time and resources attempting to have them ratified as an official international instrument. They have no legal force, either internationally or within Australia, and that has been stated by our Senate. They have been repeatedly rejected by the UN, although recent developments such as the appointment of a UN independent expert on sexual orientation and gender identity may indicate that this may change. But in Australia, the regulatory capture has been extraordinary, with Yogyakarta Principles definitions enacted into policy, legislation and guidelines, including into state-level legislation and government-issued publications. Most notably, the Attorney-General published the Australian Government Guidelines on the Recognition of Sex and Gender in 2013. They state the definition of sex is biological, although people can be neither sex. Gender is performative and based on subjective feelings. But then they state that sex and gender can be used interchangeably, including in legislation. Further, they prioritise gender over sex because apparently sex is not important in the provision of government services, data collection or medical care. And gender is to take precedence over sex if there is confusion. And all Australian government departments and agencies were expected to have their business practices aligned with these guidelines by 2016. So what does this mean for women? The original intention of the SDA to protect biological women from discrimination has had its integrity compromised, its purpose subsumed with the insertion of these ridiculous gender identity provisions. Clearly and distinctly, this has given rise to a conflict of rights between women and those men claiming a feminine gender identity. Hard-won and hard-fought women's rights are being dismissed and ignored by our government every time the legislation is interpreted to prioritise gender identity over sex. It is clear there is a conflict. The hundreds of testimonials submitted to Dr. Lawford Smith, no conflict, they said, is testament to that. So we live in a constitutional representative democracy. We are part of the parliamentary process. We have the right to participate in that process, to be involved, to be heard. We have the right to point out that these laws exist and to ask our government to fulfil their statutory obligations to women, to speak to our lawmakers, to discuss our concerns. We have the right to put in FOI requests to our government departments to ask questions about their decision-making processes, data collection and funding. We have the right to publicly criticise policies that we don't agree with, that adversely impact us. We have the right to bring a confidential complaint to the AHRC that we are being discriminated against on the basis of sex, and if that complaint is not resolved to our satisfaction, we have the right to take it to federal court. Now is the time to start reminding our lawmakers and our decision makers, the media and the broader Australian community that women have rights. Now is the time to stand up and start defending them. Thank you.